morning, everyone. Welcome to today's webinar on human rights in the workplace, resolving disputes. If this is your first time joining us, this is actually the third in a series of three where we've discussed human rights in the workplace. So the first segment in September, we talked about what are human rights. And in the second segment in October, we discussed termination of employment. And now today we'll be finishing it off with resolving disputes. If you haven't caught the first two, they are available on demand on our YouTube channel. You can also view them from both CPLE and WRC's websites. You'll find the links to view those online. And we will also be posting today's webinar in about a week's time. We'll be posting it so you can watch that one again if you'd like to follow up. Going to take a moment first. We wish to acknowledge the traditional homeland of the many diverse First Nations, Métis, and Inuit people whose elders have walked this land before us, and those persons with whom we share this great land today. So I'm here in Edmonton in Treaty 6, but we know we have people joining us from across the province today, including Calgary, where Quinn and Carolyn are. Hopefully you are staying warm as this winter has suddenly arrived in our great province. So we hope you are safe and warm today. So who am I? So my name's Jessica Steingard. I am one of the staff lawyers here at the Centre for Public Legal Education Alberta, or CPLE for short. And our mission is quite simple, and that is to make the law understandable for Albertans. And we do that through a variety of media and whatnot. So we have print resources, websites, FAQs, webinars, videos, etc., that all work to explain the law and discuss the law in a way that is understandable for most of us. You'll also see a couple faces on the top of your screen. So we have Carolyn Cron, who's the Interim Executive Director at the Workers Resource Center for the WRC. And we have Quinn Blythe, who is the Sexual Harassment Legal Specialist, also at the WRC. They'll explain a little bit more about the work that they do at the WRC, but I'll just say now that they are an agency that helps workers in Alberta. But like I said, they'll explain a little bit more later on. So thank you, Quinn and Carolyn, for joining us. Okay, a few housekeeping items. So first, disclaimers. So this presentation is meant to contain legal advice. Legal information. We are not intending to give legal advice during this presentation. We also want to acknowledge the generous funding provided by the Department of Justice Canada that make presentations like this one possible. You will see that we are recording today's session, as I mentioned, so that we can make it available on demand later on. And if you have to leave today's session early for whatever reason, or when you do leave at the end, you'll be prompted to complete an evaluation form. It's just a quick survey asking how we did today, and we really appreciate you taking time to fill that out. Okay, before we jump into the content today, we're gonna throw up a quick poll. So that's gonna come up on your screen, just to get a sense of where you are at in terms of how much you know about resolving disputes in human rights issues. I think it's coming, maybe not. Oh, there we go, perfect. Excellent. Okay, so about half of you are not very familiar at all. So we've got lots of ground to cover this morning then, so we'll get started. I see one person has said they cannot hear me. I just want to check in to make sure everyone else, Quinn and Carolyn, can you give me a thumbs up if I'm good? Okay, perfect. Okay, so let's dive in. So this morning we want to cover a couple of things. We're going to take a look first at different steps that someone can take to resolve a human rights dispute. Then we're going to dive into if it has to get to the point of filing a complaint with a third body, like a third party, where you can do that. And finally, we're going to spotlight sexual harassment, as we've been doing the last two webinars as well. And as I mentioned before, there's a lot of great work happening right now around the country, actually, when it comes to sexual harassment in the workplace. And so we just want to acknowledge that in today's session as well. Okay, so where are we starting from? I think my human rights are being violated. What can I do? So this presentation will speak largely to employees or workers and how they can resolve the dispute. But of course, there's information here for employers as well. So if you're joining us as an employer, don't worry, there's lots that you can take away as well. Understanding what options your employees have and your roles and responsibilities in this space are also important for you to know. And we'll be discussing some of that today. Okay, so we've got a mountain here. Where do we go? So the first step someone can do is to say something. And I'll acknowledge here, we will discuss each of these steps in more detail, but just as a quick overview, the first step usually is to say something. A second step is to report to management or report to an employee association or a union. And then usually the last step is to file a complaint with a third party, and we'll discuss some of what those third parties are. So say something. So if you're being harassed, a first step might be to ask the harasser to stop. If you're being denied a benefit at work, say, you might be able to talk to the person in charge about it, and they may be able to remedy that. But I want to be clear, this say something is not a necessary step in resolving a dispute. So we have put a caveat on this say something only if you feel safe and comfortable doing so. Especially when we talk about sexual harassment, the person experiencing the harassment or the human rights issue should know that they have supports available to help them, but ultimately it's their story to share. So this first step, like I said, is sometimes it can go a long way in resolving a dispute, but sometimes it's not appropriate in the circumstances, and it's not at all necessary in order to move on to the next levels of resolving the dispute. A quick question to ask yourself here is, does your employee have a policy to deal with the type of issue, human rights issue that you're experiencing? Many employers do, and they'll say, they may have a harassment prevention policy. They may have a policy when it comes to benefits and whatnot. So if there's a policy and there's a process in there on resolving disputes, then I will encourage you to look at that policy and to follow the process in that policy. If you're not sure if there is a policy or not that deals with your issue, you can always ask your employer. And on the employer side, it's your job to make sure your employees know about policies. So policies don't really do any good if no one knows about them or they're not enforced consistently. So just to keep in mind, so if there's a policy, then that's a starting point as well. If there's not a policy, or perhaps the policy tells someone to report the issue to management. So this might be a supervisor, a health and safety officer in your organization, a manager, or a human resources personnel. So these are all different options on reporting to management. Again, if there's a policy, it might say who specifically to report to, but if not, then these are all kind of candidates of who might be an appropriate person to talk to. Another option is to report the issue to an employee association or a union. We won't dive into this anymore, other than to say that if you are part of a union, then there will be a collective agreement that sets out a process. And without a doubt, the collective agreement will say what to do if there's an issue. And so so if you're a part of a union, I would encourage you to look at that option as well. As we're looking at this reporting phase, so if you're reporting it to someone and letting them know what the issue might be, whatever type of human rights issue it is, one important aspect of that is to gather evidence of the incident. So what can that evidence look like? Well, making notes is an important first step. So just keeping a diary or on your phone or on your computer somewhere, keeping a record of what happened and when it happened. But beyond just the straight facts, you can also include how you felt and what actions you took in that situation. So if you didn't say anything, you can note that and maybe indicate why you didn't. This forms a basis for you, to take to someone to report the incident, but also if it escalates any further and you end up in the legal realm, then these notes will help you and be important evidence in any kind of legal proceeding. You can also ask witnesses for statements. So say your boss always makes inappropriate, comments or jokes towards you in front of some of your other coworkers. You could talk to those coworkers and ask them to just make a note of what they saw as well. It could be informal for the process of just, reporting to management. But if it does escalate further, then you may actually require an affidavit, which is written evidence, indicating of them sharing their perspective as well. So if you have witnesses, even just to make a list of them at the very most, so that you can, or the very least, so that you know who might be able to also to share what's happening. And if there's any kind of hard evidence, such as emails or photos, print them off, keep copies of them saved somewhere. Again, just keeping that record trail. If you report to management or some other, proceeding or complaint, you're likely going to have to share this evidence. But I would encourage you to also keep a copy for yourself. So make copies of everything so that you have a copy and that you are giving copies away to the others. Okay, so what are an employer's responsibilities? So we talked a lot in the first two webinars about what are human rights and some of those issues that might come up. So issues can range on, there can be a variety of issues, sexual harassment being one of them. But what are an employer's responsibilities when an issue is raised against them or one of their employees? Well, they should investigate the concerns and they should take corrective action as needed. So that might mean disciplining an employee for their behavior, changing a policy that's discriminatory, or correcting a mistake that's been made. As we look at this, though, in terms of employers' responsibilities, there's two legal concepts that I want to discuss that also come into play. So the first one is the duty to accommodate, and the second one is a bona fide occupational requirement. So let's dive into the first one. So you may have heard this term before, but employers have a duty to accommodate an employee. So the duty to accommodate requires an employer to take reasonable steps to accommodate an employee's individual needs. It applies to all protected grounds. So examples of accommodation could be changing a policy or changing a physical working condition of an employee. So what does that look like let's give an example. So say someone can't work on a certain day because it conflicts with their religious beliefs. So the employer should try to resolve the conflict in a way that both the employee and the employer can agree to. Or it could be that an employee needs a different desk to accommodate a physical disability. So these are all steps that an employer could take to accommodate that employee's individual needs. It could also be that someone may have a medical condition and their doctor advises on what sort of accommodation is appropriate for them at work so that they can fulfill their obligations to their employer. There are lots of issues before the Alberta Human Rights Commission that discuss what happens when someone is injured at work and then they return to work, but they're unable to perform their job the same way. So they may be temporarily or permanently injured. So there's lots of cases that discuss this and then the duty to accommodate. And so time and time again, unfortunately, the employee comes back and they can't work the same as they did before, and the employer will terminate the employee. And then the employee makes a complaint to the Alberta Human Rights Commission that the dismissal of the termination was discriminatory. So what is then the boundary? What does an employer have to do to make sure that they meet this duty to accommodate? Is there a limit on this duty? And there is. And we say it's to the point of undue hardship. So undue hardship is the point where accommodation becomes a burden for the employer. So I want to highlight here. So we have hardship in this term. So that means that some hardship is acceptable, but not undue. And the two kind of reasons that would signal we're into the realm of undue hardship is if the business would incur a really high financial cost in trying to accommodate the employee, or if there would be a serious disruption to business. So if they had to I don't know, for example, rejig the schedules of a 300-person team to accommodate one person's schedule, well, that might be a serious disruption to business. So there is this limit on there. We'll also note that the courts or the legal processes do not expect perfect accommodation. So we're looking for the employer and the employee to work together on this, to find a solution that they can agree on. But it's not going to be perfect for everyone. So again, using the example of someone being injured at work and then returning to work and not being able to fulfill all their job functions as before, the employer would be expected to work with the employee to accommodate the injury. Now, importantly, this duty to accommodate could include positions outside the employee's current role. So I want to highlight a case from 2016 that was before the commission where a school caretaker was injured. And when she came back, she could not use her arm, which was problematic in order for her to perform her caretaking duties. And so she was terminated. But the tribunal found that the school had not satisfied its duty to accommodate, as it had only considered if the employee could work in their caretaker role and had not considered other roles the employee could fill. So from an employer's perspective, this duty does put some onus on them to make things work and to maybe get creative in their solutions. So the second legal concept we're going to look at is called a bona fide occupational requirement. So if an employer receives a complaint of discrimination in the workplace, they may respond saying that behavior was a bona fide occupational requirement. So in this case, we were looking at standards, policies, or rules that are discriminatory, but that are a necessary requirement of a job. So in these cases, if an employer says, no, that discriminatory policy is necessary, and so is a bona fide occupation requirement, they must be able to show that it would be impossible for the employer to accommodate the employee without undue hardship. So this is where we see those two concepts linking up. So if an employer it's beyond or creates undue hardship, then it may be a bona fide occupational requirement. So let's look at an example of that. Let's say an employer hires drivers, let's say truck drivers, and they require them to have acceptable vision and a driver's license. Well, you could say that requiring good vision is discriminatory because it discriminates against those with poor vision, which is a physical disability, which is a protected characteristic under the Alberta Human Rights Act. But having good vision is necessary for the truck driver to safely perform their job. So in that case, the employer would say that discriminatory policy is necessary, and so it's a bona fide occupational requirement. Another example is people working in a liquor or cannabis store must be 18 years old, and that's the law. So you might say, well, that's age discrimination for someone getting a job, but that's the law. So there's no way around that. It's a necessary requirement, and so that would not be an example of age discrimination then. If you have any more questions or are looking for more information on the on bona fide occupational requirements, there is a ton of great information on the Alberta Human Rights Commission's website, especially from an employer's perspective. If you're looking for resources on it, there is lots on their website, so I would encourage you to go check that out as well. Okay. We don't want to, as we've done the last couple of webinars, we always want to make sure that we highlight resources that are out there to help people. But before we jump into that, we're going to do a couple quick polls just to kind of solidify some of the information that we've taken in the last 20 minutes. So Natalie's going to pop those up on your screen. So true, false, an employee must report the issue to someone at work before they can file a human rights complaint. And half of you said false, and that is false. They don't have to report it. It's generally, like I said, it's a first step that can go a long ways, but in some cases it's not appropriate to do so. And so that's not a pre-requirement to filing. I think we have a couple more questions. So true or false, an employer's duty to accommodate means they must do everything possible to meet the employee's needs. (50-50). So I was kind of tricky on this question in that I used the very strong language of everything possible. And when we look at the duty to accommodate, we talked about that limit of undue hardship. So that would mean that an employer would not have to do everything. They have to do everything to the point of them, of causing them undue hardship. So I would say that one is false. And I think we have one more. An employer can have discriminatory standards, policies, or rules if they are a necessary requirement of a job. True or false? And that one is true. And that's what we just talked about, the bona fide occupational requirement. Well, thank you guys for breaking up some of the talking with those quick questions. And now I'm going to turn it over to Quinn to talk about some resources that are available to help you resolve the human rights dispute.
Hi, good morning, everybody. My name is Quinn, and I am the Sexual Harassment Legal Specialist at the WRC. And I'll talk a little bit more later on about what I do and what we do at the Workers Resource Center. But first, I'd like to go over some different reporting methods, so different places that you can file a complaint. So the four that we're going to go over, the first one is going to be the Alberta Human Rights Commission, which deals with human rights issues. We're then going to talk about occupational health and safety, which is workplace health and safety issues. We'll then briefly go over civil court, so civil wrongs between persons. And then finally, we'll go over the police, so criminal offenses. So we'll talk more about those specifically. So the first one is the Alberta Human Rights Commission. So the Alberta Human Rights Commission protects people that are being discriminated against based on the protected grounds. So you can file a complaint to the Alberta Human Rights Commission. And so the first thing you would do is fill out a complaint form, which you can find on their website. At that time, the commission will review it, review the complaint, and then if accepted, they'll forward it to the respondent. So that's the person that the complaint is against. Then the human rights officer assigns the case to conciliation or investigation. A director reviews the case. And then finally, the director can refer the case to tribunal for decision. So there's lots of information on the Alberta Human Rights Commission website, and you can also call the commission anonymously to discuss the situation. So this is for complaints that need to be made on discrimination based in Alberta, but for those that are under federally regulated workplaces or industries, they would make a report to the Canadian Human Rights Commission, which is a very similar process. So the most important thing to remember when filing an Alberta human rights complaint is that the complaint has to be filed within 1 year of incident. So from the 1 year date that the discrimination took place, the complaint needs to be received by the Alberta Human Rights Commission. And there are several different outcomes. So they can be pain and suffering damages, so financial compensation, changes in policies. They can request that employees take training. They can help somebody get a reference letter. There's lots of different outcomes that can happen if the Human Rights Commission finds that there was discrimination. Next, we'll go on to occupational health and safety. So occupational health and safety laws in Alberta outline the obligations for employers, supervisors, workers, service providers, and more. So they ensure that workers are safe and make it home safely every day. So under occupational health and safety, there are obligations for the employer and for the workers. So some of the employer's obligations are to ensure the health and safety and the welfare of all workers at the worksite and those around the worksite. And employers also have to make sure that none of their workers are subjected or participate in any harassment or violence in the worksite. So occupational health and safety does say that harassment and violence, including sexual harassment, is a workplace hazard. Employers also have to ensure the health and safety concerns that are raised by their workers are resolved in a timely manner. Workers also have some obligations, and that is to take some reasonable care to protect the health and safety of others on the site, to refrain from causing or participating in any harassment or violence, and to report to the employer or a supervisor a concern about unsafe or harmful workplace conditions that could be dangerous. So you can make a complaint to the Occupational Health and Safety. So you can do so by calling the office. So it would be federal, again, if you're in a federal regulated industry, or the Alberta Occupational Health and Safety. You can file a complaint online if it's not urgent. You can also call and file a complaint. And when you do file a complaint with Occupational Health and Safety, you can do so anonymously. And then at that point, Occupational Health and Safety would investigate the complaint. So once they receive the complaint, they will investigate it. And again, there are many different outcomes. So they can issue a stop work order. They can fine the company. They can be many different things that can come from this. Occupational Health and Safety takes safety very seriously, and they take complaints very seriously.
Okay, I'll jump back in here. Oh, okay. I'll jump back in just for the civil courts portion here. So civil claims are wrongs between two people. So for example, an employee and an employer. The courts have held that employers can be vicariously liable for the actions of their employees. So basically, if they are allowing a work, say they're allowing a toxic work environment because people are harassing each other, if they are allowing that kind of behavior, then the courts have said that an employer can be responsible. Some common types of civil claims that we see in this realm of human rights issues might be wrongful dismissal, or vicarious liability for other employees' acts. We sometimes see that when in cases of sexual harassment, that the employee will sue their employer as well for creating that toxic work environment. I won't go too deep into the process for filing for a civil claim. There's a whole lot of process behind it, and it depends on which court you're in and whatnot. So just very briefly, the process would be to file a statement of claim. If you're in Queen's Bench, Court of Queen's Bench, it would be a statement of claim or civil claim in provincial court. And then there's a court process. So that would allow the other person to respond to it and make their defense. Our court system encourages opportunities to settle the dispute. So we recognize that going to a trial is not necessarily a good way to resolve a dispute. It can create a lot of animosity. It's timely, it's expensive. And so the court processes do have opportunities for the parties to settle. But of course, if that's not possible, then it would go to a full trial. Some possible outcomes: the civil court process does provide outcomes for the employee themselves. So similar to the Alberta Human Rights Commission process, they can get pain and suffering damages. There might be payment of out-of-pocket expenses, lost wages, etc. So the civil court, though, really is mostly dealing with money. That's what they deal with. Some people may be incurred, if they have been wronged, what they really are seeking is an apology and some sort of recognition of the wrong. But unfortunately, our court system does not provide that type of outcome. Like I said, largely in the civil court realm, we are looking for compensation. As well, there is a timeline on this one here as well. It's usually you have to file a claim within 2 years. But when it comes to sexual violence and offense or any kind of behavior related to that, there's usually no limitation. I would encourage you, though, not to delay, because there is a kind of a narrow definition of what constitutes sexual violence in this regard. So if you have any questions, to seek out some legal help to make sure that you don't miss that limitation for filing. Because if you do file outside of what we call the limitation period, then the courts can bar your claim and you won't be able to move forward. There are some services for free legal help available. There's community legal clinics across the province. There's civil claims duty counsel in the Calgary and Edmonton courthouses that support people with civil dealing with the civil courts. And the WRC will talk a little bit about some of the support they provide as well. Okay, back over to you, Quinn.
Great, thank you, Jessica. So now we'll get into the police. So this can be city police or RCMP, depending on where you're located. So you can make a report to the police by calling them. They will investigate. They will then decide whether to lay charges. And if they do lay charges, the accused would go through the criminal court process. So I would say, especially when there's any sort of stalking behavior, threatening behavior, that it's, the police would be the best reporting option at that point. So the possible outcomes for the police is that it only affects the accused. So there could be charges, they may choose, they may not be able to charge, there could be acquittal or conviction. So anything from the result could be probation or mandated programming, different options as there are in the criminal system. And there are no deadline for filing a police report, but for accessing some supports there are. So next we'll talk about the Workers Resource Center, so the WRC. So we offer many different services. So we have a casework program that works with workers throughout Alberta to go over different employment standards, employment insurance, WCB, everything you see on the list here. So they can assist workers navigate these different legislations and file complaints if necessary. And we also offer workshops on all of these different legislations as well. And then, sorry, I'll backtrack for a minute. My program there is a sexual harassment program. So I do some casework. I offer casework to workers throughout Alberta that have experienced sexual harassment in the workplace, again, just to navigate the different options that are available. And all of our services are free. So next we'll talk about the CPLE website. So the CPLE website has many different FAQs, articles, info sheets, many things about your rights at work, including human rights, what to do if you've lost your job, information on bullying and harassment, minimum standards, occupational health and safety. They have a huge amount of information on their website, and it's very helpful. So I would encourage you to check that out. There are some other resources as well. So we've really talked about it, but the Canadian Human Rights Commission is who you can make a complaint to if for the federally regulated industries. So that's like banks, railways, telecommunications. There's a list on their website, and their website is really great, so you can check that out as well. There's also employment insurance if you've been laid off. Lots of information on employment insurance, and you can, like I said earlier, you can give the WRC a call if you need some help with that. Next is employment standards. So they set out these standards for workers in Alberta. So there's lots of information on their website, and again, you can contact the WRC for more information. Jessica mentioned earlier that there's many community legal clinics throughout Alberta that offer different free legal services. So you can check out their website to find one near you. And lastly is the lawyer referral service. So through this service, you can get connected to a lawyer in your area. Some offer like a 30-minute free consultation. And it just connects you to a lawyer in your area that specializes in the services that you're looking for. So after each of our webinars, the last two and this one, we have info sheets that are available that you can reference that cover today's discussion. They will be available both on the CPLE website and on the WRC website. So we're just briefly going to talk about sexual harassment in the workplace. So there is help available. So if you are experiencing sexual harassment in the workplace, there are many different resources available. And it's important to look into if your employer does have a harassment policy. If you are witnessing sexual harassment in the workplace, there's different resources too. So we encourage allyship. So that's speaking out, reaching out to the person that is experiencing the harassment and offering your support. And there are different, and you can also look at the harassment policy from your employer and see what that looks like and how they suggest that it be addressed, and to share the information that you learned today and different information you've learned on, and give that to the person that's experiencing the harassment, so that they feel supported. And as an employer, are you preventing sexual harassment in the workplace? So we know that healthy and respectful workplaces discourage sexual harassment. So there are many different tools and different things going on, as Jessica mentioned earlier, to help employers build a safe and respectful workplace. And to also ensure that the harassment policy is known and being enforced. So one of those campaigns is the Moments Matter campaign, and that is through the Association of Alberta Sexual Assault Services. So these are the same folks that bring us the one line, which we'll talk about in a couple minutes here. But they are sharing different moments and stories and tips and tricks on how to make workplaces safe and respectful, because we know, like we said earlier, that does discourage sexual harassment. So check out their campaign. They have lots of great information there. Oh, here we go. So this is a program that I'm involved with at the WRC. So we offer free seminars on workplace sexual harassment. We also do intake and referrals and one-to-one casework. So I can work with anybody in the province who's experiencing workplace sexual harassment. So I can meet with them on one-on-one to go over their different options, help them file complaints, lots of different things. So please reach out to me if you'd like some more information on this. One line, so this is the same folks that are doing the Moments Matter campaign. So this is a one line. So this is a number that you can call or text or chat online that is the same throughout the province. So this is, it's unique to have a province-wide line. So this is a really good support. When you reach out to this line, it is answered by trained professionals that can connect you to supports and resources in your community. This line is also for those that are supporting somebody who is experiencing sexual harassment or sexual violence. So if this is going on in your workplace, if you are witnessing this, this is a resource that you can reach out to. And it's absolutely free, it's province-wide, and they connect you to many different supports and resources.
Okay, thanks, Quinn. So there's, as you can see, there's lots of great resources available to help. So if you are in a position where you are looking for something, some support, please reach out to one of the resources that we've highlighted. And a great one-stop, obviously, is the Workers Resource Center. We're going to wrap it up with a couple examples. We've been using examples throughout this series to kind of highlight some of the concepts we've been talking about, especially as it relates to sexual harassment. So I'm going to draw on a couple of these examples that we've already seen, but I want to talk a little bit more about some of the steps that these individuals could take in response to the sexual harassment issue being raised. Again, these are not true situations. The names are not reflect anyone that we know. These are made up scenarios. So we met Alex, I think, in the first session when we talked about how Alex works in construction, and their coworker repeatedly asked them out on a date. Alex always says no, but the coworker's getting more and more persistent. The other coworkers and boss just laugh at the situation, and it gets so bad that Alex no longer feels comfortable at work, and ultimately they quit their job. So I want to use this time. We're going to pop up another poll on your screen, and you can select all the different options. What kind of steps do you think Alex could take in this situation? And you can check multiples, but really just kind of bring together the information we've seen today and discuss how it might apply in this situation. Okay, so a variety of answers, which is what I was expecting. And there's no, I should say, there's no wrong answers here. So I'll go through each of them. The first is to report the incident to their supervisor. In this case, we see that the boss seems to be joining in on the harassment, but there may be someone higher than that they could report it to. So reporting absolutely is an option. They could file a human rights complaint against their employer for this behavior. And they could also report to Alberta's OHS office, indicating that this might be, like as Quinn mentioned, sexual violence is part of the definition of violence in the workplace, and it's considered a workplace hazard. And so the OHS might be able to investigate this sort of complaint. 33% you said you could start a civil claim against the employer. That may be an option. We talked the last one, when we talked about termination of employment, about constructive dismissal. And that is when someone feels they have no choice but to quit their job because a fundamental part of their job has changed. So in this case, they could say that try and make a claim that the workplace has become so toxic that they felt they had no other option but to quit. As I indicated that in October's webinar, if you are looking at a complaint for constructive dismissal, I would encourage you to get legal support. They are more challenging claims to make, and so I would encourage you to get some help from a lawyer or some other legal support if that's the route that you are looking at. In this case, reporting the incident to police, that may be an option if it is at the point, as Quinn mentioned, where it's like the coworker is stalking her, harassing her. So if it elevates to the point of a criminal offense, then absolutely the police might be an option there. They can call or text the Alberta One line to connect with local supports. Again, this would just give some support to Alex as they navigate navigate this experience. Almost all of you said they can call the WRC for guidance. Absolutely. And we would encourage you to do so because they can help you navigate some of these different legal arenas. As we mentioned last time, there's lots of different avenues available and they don't all talk to each other. So employment standards doesn't necessarily talk to employment insurance, doesn't talk to Alberta Human Rights Commission. And so really there's a lot of different sometimes applications or complaints that need to be filed, and the WRC can help you navigate where to take those. And a final option I had on here was to do nothing, and nobody indicated that that was something was an option, but I do want to highlight doing nothing. So doing nothing is just as valid a response as any other response. It really is up to the person experiencing the situation to decide what steps they want to take. And there's a lot of reasons why someone might decide to do nothing about it. And it really is up to the person experiencing it. And so we want to make sure that we give space for that and don't look at it as condoning the behavior or letting it go. In fact, it may be a way to move on, or it might be for their own sake of their own mental health that they decide that's the best option for them. But it is a very valid response. And again, we want people to know that there are options and there's help available, but ultimately it's their choice. Okay, regarding time, I have 4 of these examples, but I'm going to skip through to the last one so that we have lots of time for questions at the end. So I'm going to skip through Sam and Jess, and we're going to hit Rory. Can't tell I was watching Gilmore Girls when I decided to make up this example. That's where the name came from. So in this example, we see that Rory is pregnant. One day her boss asks to meet with her, and during the meeting, the boss makes sexual comments about her being pregnant. This happens again. And then a few weeks later, the boss touches Rory inappropriately, and Rory is stunned. Soon after, Rory receives a written warning of her performance, and it says that if her pregnancy is interfering with her job, she should find other work. And less than a month after receiving that letter, she then receives a termination letter, and her ROE indicates that she quit. So again, the same question is going to pop up. What steps could Rory take now in this situation? So I'll give you 30 seconds to make that decision. Okay. So in this case, some of you said they could report the incident to the supervisor. Absolutely. We're talking about a boss here, but there may be someone higher that they could have reported, that Rory could report this situation to. Could they file a human rights complaint? Most of you said yes, and absolutely this would be an option for Rory. Report to Alberta's OHS office, again, a workplace hazard, so they may be able to report there and OHS can investigate. They might be able to start a civil claim against the employer. This one might have two kind of branches. So one might be for wrongful dismissal, saying that she was terminated without cause. So that would be one claim. And another claim might be, again, we talked about that vicarious liability. So again, for the employer creating a toxic work environment that's created harm for Rory. Reporting to the police is also an option. Again, depending on the assault, sexual assault is any unwanted touching that is sexual in nature. And so that might be an option as well to report to the police, and there may be some charges that could come out of that. They can call or text Alberta One line to connect with local supports, absolutely. Again, calling the WRC, always a great option. And I see some of you have said doing nothing. Doing nothing absolutely is also a response that Rory could take. Now, I might have mentioned this last time, that this is actually a real case. So the name Rory was not the name of the complainant in this situation, but this case did end up before the Alberta Human Rights Tribunal. And the tribunal awarded her, they awarded her wages lost between her termination and the start of her maternity leave. So in this situation, Rory was terminated when she was, I think she was about 7 months pregnant. So had she not been terminated, she would have worked right up to when her maternity leave started, probably another month and a half-ish. And so the tribunal awarded her those wages that she lost in between her termination and when her maternity leave would have started. They also awarded her $25,000 in damages for loss of dignity. And the tribunal made this award after looking at the facts in this case, which were quite stunning. And they also looked at similar cases to decide what would be an appropriate compensation to acknowledge the harms that Rory had experienced. We'd also talked about in this case that the ROE indicated that she had quit, which caused Rory further problems because when you quit, typically you don't have access to employment insurance. And so there was just a snowball of effects that compounded here in Rory's situation. So absolutely some of those. We don't know in this case if Rory pursued reporting to police or pursued a civil claim, but that doesn't mean that those weren't necessarily options. Okay, well, with that, we like to leave it time for questions. So hopefully that kind of, those examples showed some different options available and what that could look like. But we would like to open it up for a discussion and questions. So please use the Q&A chat function on Zoom to ask your question. We'll be monitoring that. And Quinn and Carolyn and I are all available to answer. I will preface that we can only give legal information during these webinars. We cannot give legal advice. So we won't be able to answer your specific questions if that's what you're looking for. But please throw your questions in the chat and we will get to those. And just a reminder that when you leave today, you'll be prompted to complete an evaluation form, which we really appreciate you taking just 30 seconds to fill that out and let us know how we did today. So I'm opening up the Q&A. I don't see any questions in here, but that doesn't mean there aren't necessarily any. So I'll give anyone 30 seconds to type their question in so that we don't miss any today. And I see as well that Natalie, who's the face behind the CEQLI logo on your screen, Natalie's our education and design specialist. Education and evaluation design specialist. So she's been throwing some links up in the chat if you're looking for more information on some of the topics we've gone through. And I see that she just threw one up. The info sheets that we chatted about, Quinn mentioned earlier, the 3 info sheets that correspond with each of the webinars, they are also available in French. So the webinars aren't in French because I don't speak French very well, but the 3 info sheets are available in French. So thank you to our partners at AJAPA for helping making sure that those were available. Okay, we have one question. My chattering for 30 seconds helped, and we have a question here. If you filed a complaint with the union about a religious exemption for COVID being denied, I'm under the impression you should file a complaint with human rights as well. Carolyn, did you want to take that one?
Sure, I can take that. So there's kind of a different moving part. So firstly, typically no, your avenue for exploration initially in a unionized environment would be your union. So that would be your first mechanism. The second thing is human rights is being very particular about the exemptions and what they're actually going to accept as exemptions. So just a declaration of a religious exemption may not be enough information. There might be additional information required. And then there also might be secondary conversations around, you know, could your job be performed at home? Is there other kind of accommodations that could be explored? I think it's just important to put a caveat here that there will be a very limited scope of exemptions under the COVID-19. I think you're referring to vaccination when you say COVID being denied, because there's 2 pieces. Human rights has a duty to accommodate, but they also have a duty to protect their workers and their clients and their employees and their customers in an environment. So for example, if you could perform your job from home continually, then something like that may be accepted. But if you worked as a healthcare aide in a assisted living facility, that may be not, because that would jeopardize and compromise the health and safety of the other people in those environments as well. So in relation to this question, human rights typically would not be my first step. I would go back to my union and I would make sure I have appropriate documentation that suffices what and why the religious exemption is there, and see if something can be outlined that way, because any exemptions will require documentation as far as I understand it.
Excellent. Thanks, Carolyn. Okay. I don't see any other questions. So if that's all, that's totally fine. We can wrap it up for today. We have just a few minutes left. I want to thank both Quinn and Carolyn for joining us on this webinar series. And we hope that you found some useful information to take away. And like I mentioned, in about a week's time, the webinar will be available on demand, and you can access that from both CEQLI.ca as well as helpwrc.org, both of our organizations' websites. So watch for that information there. And thank you so much for joining us. And we've got lots of different webinars and whatnot coming up as well. So definitely check out our agency's websites to see what kind of further information we are offering going forward. So thank you so much for joining us, and stay warm.